It's really difficult to manage a death of a person if you don't have any means by which to access the courts. But that's not the only problem that I see. Because of messes, family relationships are torn apart, resources are depleted, and things are lost too quickly, especially if there's young kids, young adults involved. So my goal is to empower you with some education to understand the deep conversations that you should be having with your loved ones so that you actually start having not just paperwork, but a strategy in place to protect your family. All right. Feel free to put your questions in the chat at the end of the presentation. I will address as many as I can. Just remember, they're going to be general answers because I am not your attorney. We're not in a confidential meeting, but it is a good way to get general responses to things that are kind of like digging at your brain. Okay, so first thing, right? So many people think that estate planning is just having a will. But wills force your family into court, right? From the very beginning. They also do nothing if you're incapacitated. So, for example, let's say you suffered a severe, infection, you're stuck in the hospital, you're incapacitated. That will is not going to do anything about your kids being taken care of or your spouse having access to your things, right? Things are frozen when you're incapacitated. And it's not just Alzheimer's, it's not just dementia. Many things can incapacitate us. So wills don't really serve us in the way that people think. They don't keep businesses running because wills don't act for a business. And they also don't avoid court because the only way to make a will effective is to have a court enter an order saying, we're approving the will. So definitely don't rely on just having a will. A lot of people also think that estate planning has to do with just like paperwork. They think of maybe a power of attorney. They think of, the DNR orders. Sometimes they think of deeds that people try to do to say, well, if I pass away, it's just going to go directly to this other person. But documents without strategy are the reason why I have half of my practice devoted to lots of litigation resulting from really poor DIY planning. Okay, people that thought that they had everything set up just because they had created a will or because they had put these people in title with them, and then they end up with the reality of the mess. So their family members do, right? Courts don't care about what your intentions were. They're just going to implement whatever the law is based on whatever the mess is that's created. And so that's another reason why we can't look at planning as documents. So I want you to remember strategy, right? Real strategies is what we're discussing today, involves more than having expensive paper. Documents don't help you in selecting family members. They don't discuss those really important dynamics that help us understand who is probably good for a role, who's probably going to need some protections and how things are left for them, who is going to have some planning that might have some tax consequences involved. Documents don't do any of that, okay? And conversations with a legal Zoom screen are not going to happen. So self-help and DIY plans generally fail people for that reason. Legacy planning is what we do. We do legacy planning because it's a system. So yes, of course, there are important legal instruments involved. You have to have that, but that's the very bottom basis. We have strategies. So we are with our clients for a sufficient period of time that they become trained in understanding how to always have a place where their assets are listed, how to always make sure that whatever they do bring into their life is now accounted for and tied to whatever plan that they've created, and that they're able to have those questions, those conversations with legal counsel when things change, because what's guaranteed in life, right? Death, taxes, and change, really. And so you want to make sure that whoever is assisting you with estate planning has a system in place to take you beyond documents. Legacy planning, of course, it's for everyone, right? It doesn't matter if you're 80 years old, 60-year-old business owner, you're on your third marriage, no judgment, by the way. I am also on my third and last marriage. If you're a real estate investor and you've got lots of moving parts, different investments in different states, or maybe even different countries, you all benefit from legacy planning, okay? One of the things that I mentioned at the beginning is that I want you to understand and feel empowered to have those conversations, those really important conversations with loved ones, so that you start developing a strategy. And so I've created some tools here. Okay, this is an interactive webinar. We're going to have some questions. There's Julie, I believe, is going to be placing a form so that you can use that to answer the questions. It's confidential. Nobody sees your answers. But this is a tool to help you identify some of those gaps in what you have right now, but also know what kind of questions to ask your loved ones regarding your planning. Okay, so exercise number one is all about incapacitation. What if you couldn't speak for yourself tomorrow? Okay, this is the reality for people that are incapacitated. You are trapped in your body at the mercy of other people. So number one, who would care for you if you were incapacitated? I say that because sometimes we have family members who like to raise their hands and meddle, and they might be the last people that you want. Okay, they might have completely different health values than you. They might have demonstrated some personality traits that you do not trust, so we can't rely on the right person raising their hand, because often the wrong people raise their hand. Two, if the right person raised their hand, would they know where your things are, your assets, the things that are useful to take care of you? Because once you're incapacitated, you're no longer producing income. You're not making out of like your own activities income. So you have to rely on what's there. If somebody raises their hand and they're actually somebody you trust, do they have the ability right now legally to convey your wishes to your doctors or to speak with the billing department at the hospital? Because they probably don't. The other part is, how do they even access the funds to pay for the things that you need day to day, right? Your home, your bills, maybe the nurse that's coming in. We can't rely on the people that would raise their hands, that we would love to raise their hands, having the money to do this for us. It's on us to provide those assets. Okay. All right. Exercise number two. This is, what if something happened to you? Okay. Tonight. And this is for you, those of you that have children, right? Minors. Or for those of you that are kind of stuck in the sandwich generation and are now taking care of your older parents, okay? There's a lot of us who are now taking care of elderly parents. Who watches them when you're working late, or when you're out in an event, or when you're out of town? You might think, oh, the babysitter, or I have a neighbor that comes and stays with mom, or etc., right? But if something happens to you and they can't get a hold of you, who do you think they're going to call? Right? The number one call is going to be to law enforcement, but law enforcement isn't going to be the best place for children who are completely unfamiliar with like the foster system and total strangers. And for elderly parents who often suffer from memory issues, it's incredibly difficult to be in a different place, in a different location where you don't know, but that's where like Adult Protective Services has placed you, right? Very, very tough for them. Instead, right, you probably want somebody that understands your parenting values, the structure that you've set up to take care of those loved ones, especially if they have special needs, and also provide them with the resources to take care of those people that are dependent on you. All right. Exercise number three. What happens when you pass away? What happens a day after you die? Okay. Again, there's probably going to be somebody who steps up to handle things. They might just raise their hand because everyone defaults to them and they're going to feel completely overwhelmed and exhausted. They might raise their hand because they see an opportunity to get a hold of your assets. And we just had a recent consultation where the ex-husband of the surviving spouse somehow ended up being personal representative of the estate. Yeah. difficult thing to discuss with the sibling of the deceased person, right? Um, Also, these people, right? Your loved ones or the ones that you're not very fond of, do they know where your assets are? Do they know what you have? Right? We're not very open about what we do have. We don't say like, oh yes, and I have a bank account here, here, and here, and my investments are held here and here, and here are the account numbers. We don't say any of that. But we have messes that we leave behind if we don't organize this and leave it in a place where the people that we trust can actually access that information. Okay. If you didn't leave any sort of planning behind, do the people that raise their hand necessarily know where your loved ones, your heirs are? There's a surprising amount of estranged family members, but much to the chagrin of people, you have to report absolutely every heir, step sibling, half sibling, all those levels to the court when a person passes away without a will. And sometimes if they pass away with one, okay? And finally, do they have the money to hire a lawyer for probate? Okay. Probate is very expensive. It is very time consuming, and there can be a lot of wheels in it. You know, what people think is simple ends up being not so simple. And so, for that reason, I want you to have these conversations with your loved ones. And it's okay, right? You're probably going, oh my God, I really don't have a plan. I have no idea what I'm doing. I haven't even thought of these things before. That's okay. It's okay. You're taking the first step by just being here and learning about this. Okay. Here's something that a judge mentioned that just really stuck with me. And he's a probate judge. Okay. Um, and he said, you have no idea how many people I come across that, after they've experienced the horrible, you know, um, interactions and just what a courtroom is like, okay, and what dealing with litigation is like. And it's like, how much would you pay the right lawyer to bring you back from the dead and fix this so that your family, your loved ones would never have to deal with this? And that's the reality, right? We don't get an oopsie redo once we're gone. And gone can mean incapacitated permanently. Gone can mean deceased, right? So it's, do we want to do this in a rash way that's probably not going to work? Or do we want to take the time to protect our loved ones from very serious consequences, something that could take a significant part of their lifetime if it's not done properly? And yeah, I say a significant part because I've dealt with probate cases that had to be reopened after 12 years. They didn't know some assets were missing. Okay, I have another tool for you. It is a different way of approaching the conversations, identifying the gaps that you might have. Okay, it's called our legacy leak test. You can use that QR code. I think they're also going to put a little link in the chat if you can't scan the code. It's a very easy set of 15 questions that's going to help you identify what your weaknesses are and what you have right now, which then allows you to have those important conversations. It also will let you know if you're potentially the right fit to work with us, okay, to have access to our 22 critical risk factor worksheet, to sit down with me in a legacy planning session. And, you might not be a right fit. That's okay. But I want you to at least reach out to a professional based on the gaps you identify. Okay. I'm an attorney. I have to encourage you to do the right thing. We are offering a golden ticket. It's super simple. Okay. It's a 15-minute discovery call with my team just to see if we're the right fit for you. We might not be the right fit for you. I don't handle elder law planning, for example, and that's okay. We'd rather, if you want, give us a call and we'll help guide you to who does elder law planning. My job as a counselor is to make sure that people have access to lawyers that do things the right way, because there are too many that do things the wrong way. In fact, today I was working on a 9-count, 23 pages long complaint, which includes a defendant lawyer who absconded with $1 million of their client's funds. So you got to be careful. You got to make sure that you're evaluating counsel as well for helping you out in whatever legal aspect of your life. Okay. But that's the QR code. Again, that's just to schedule a free 15-minute call. And they'll tell you about how you can sit with me at a legacy planning session for less than what we normally charge. So that's why we offer those spots. But let's move on because I want to keep teaching you. Okay. Cheap planning mistakes that are really costly. And I say really costly because people think these are strategies, but they're not really the best strategies. One is when you add a person to title with you, right? Joint tenancy. Oh, great. I'll pass away. It'll go straight to them. Well, you can outlive them, right? Two, you're adding them to title with you. So now you've opened up that property to all of their creditors. Yay. um, life estate deeds. Okay. Life estate deeds can also trap you. They, some people think, oh, I've retained all the rights if I did it the right way. Yeah, but if you're becoming incapacitated, that's locked in. And what if those people that are the other parties end up not being the right people? Okay. So it's not the best process. Naming certain people as the sole trustee, the sole beneficiary, that just opens things up to creditors. Thinking that you have to appoint people to help you out based on the order of birth, that no, it's not a great way to rely on it. And also failing to do any disability planning. So many of the phone calls that we get are as a result of people failing to do disability planning. And it breaks my heart to have to tell them, I'm sorry, but once your family member is incapacitated, you can't do any planning. You're going to have to go to guardianship court, get appointed a guardian to maybe have the court allow some estate planning to take place. Often doesn't happen, okay? If you become incapacitated and you don't have a plan in place that allows the right people to act and take care of you and make those medical decisions and manage your finances and know where the finances are and so forth, you're stuck with guardianship court. Okay, it's part of the probate branch here in the state of Florida. Just know there's no automatic decision maker under Florida law. Okay, your spouse has the same standing as your sibling, has the same standing as your children, has the same standing as your parents. That's why the Terry Schiavo issue, remember Terry Schiavo back in the early 90s? That litigation lasted 15 years. Okay, so please don't think that the guardianship process is going to be easy. It's also very expensive. Why? Because there's experts involved. You really do have to get court approval for many, many things. It can be quite expensive. I had some clients that told me they had to get guardianship and it cost them well over $35,000 for just a few months of those proceedings. So guardianship court also has other drawbacks people don't know about. One, you might have to pay a bond, okay? Two, you might have established a case and finally felt like you were okay, secure, you kind of knew what the judge was going to be like. Guess what? Judges go on rotation. They get changed every couple of years. You might have a new judge who is completely different in their demeanor of what's going on. The person who is incapacitated loses basic rights, okay? You can't drive, you can't vote, lots of things. And there's permanent filings that need to be done. However long the person lives, there are filings that are required every year. Needless to say, it's not the best approach. So remember how I mentioned that $35,000 disaster, right? And these were adults trying to get guardianship of their adult daughter, somebody in their 30s, right? Again, we're assuming guardianship involves little kids or maybe elderly people with dementia. We can't ignore the fact that a person that we love might suffer from mental health needs, right? That can happen to us too. So guardianship can suck us into that if we think, oh, I'm young, I don't need a power of attorney, I don't need these things, I don't need a plan in place, I don't need to let people know where my things are. You end up with this, right? Your parents having spent $35,000 of their savings to just be able to have authority to take care of you. And then I spoke with my clients later on, about a year after, and they're like, yeah, Natalia, we've had to pay $20,000 this year alone in just maintenance under the court system. So again, very expensive. Probate is the process by which assets get transferred after payment to creditors to heirs at law or beneficiaries if there was a will. But it is a court process, okay? There's no like the typical thing you see on TV where somebody unscrolls a will and they're like, and to you, he left blah, blah, blah here. And to you, he left blah, blah, blah here. That's not how it works, okay? The will has to be submitted to the court, reviewed. The court will say, okay, this person might be able to do the role, but guess what? You're going to have to pay a bond for the role. You're going to have to prove by putting a lot of money down that you're not going to abscond with the money. So that's the thing about probate. It's very, very expensive. And then even if you get appointed, all of the people that have priority at the very beginning are creditors. And there's a big period called the creditor's claim period. So I'm gonna do a little Q&A of my own in the chat, okay? I want you to put a 1 in the chat if you think that bonds are maybe somewhere around $1,500, $3,000, maybe even $5,000. Put a 1 in the chat if you think that's the case, like what typical personal representatives end up paying for bonds, okay? Put a 1 in the chat. Don't be nervous. Don't be shy. It's okay. You're learning, right? Okay. Put a 2 in the chat if you think that bonds are maybe going to require you to pay somewhere around $10,000. Okay. As an average. I see that you're all being very shy about it. It's okay. Write it down on your sheet of paper. I'm going to give you a reality. My client today, she's the daughter of the person that passed away. She's a responsible adult, nothing weird, no strange credit history or anything like that, okay? The judge required a bond of $150,000. Yeah, okay? I have another probate case in which the only asset was a truck, and the judge required a bond of $18,000. Okay, so bonds are largely what keep your family members out of even being able to open up a probate case, because it's just like, where are you going to come up with that money? Okay. So the other things about probate that are just not the best. Any of those filings are public, same as in guardianship proceedings. So people know, like, what are the assets this person had? Who are the potential heirs? You know, if they're minors, how do we approach them, right? There's bad people that look at these records to take bad action, okay? At the same time, because of poor planning, you might have to do multiple probates. There's another probate that we're assisting with where, like, mom died, but 3 of her kids also died. So there's 3 other estates. And then one of the grandchildren also died. So there's another estate there. So this is like a multi-layered thing that happens more often than you think. And because it gets more and more expensive, the more probates you have to open up, the more likely your family will need a contingency lawyer. Okay. Put a 1 in the chat if you're familiar with all the billboard lawyers that are like, you don't have to pay a thing. they're for personal injury cases, right? For car accidents and things like that. I see those everywhere. Okay. I'm the 1 in the chat. I'm going to put it in. Those are contingency lawyers. Okay. So they will take a giant chunk of whatever you win, quote unquote, in order to represent you without you paying for their fees in advance. These are contingency lawyers. Contingency lawyers are also seen in probate. They will also take 30 to 40% of your assets, your loved one, the assets your loved one left behind, in order to represent you, okay? Because it's a huge risk, right? They're acting as your bank at that point, and so they're going to make it painful. So your family doesn't necessarily want to end up with those means as the only way to access the courtroom. Because probate is so expensive, because so many people are thinking, oh, you know, like everything will be fine, right? Relying on luck. There's $70 billion worth of unclaimed assets in the United States right now. Over 2 billion in just Florida. And it just goes to the state after a certain period of time where nobody, no family member, nothing raises their hand. Okay. And after a certain period after that, it just becomes an asset of the estate, which is to me an involuntary tax. We come to the state of Florida because we say, oh, there's no income taxes, but there is an involuntary inheritance tax that we pay when we can't afford probate, and it just goes to the state. All right. So some people think, oh, well, I've heard about trusts and I have a trust, right? Is that enough? Okay. Trusts are as good as the people creating them. I'm going to say that. Okay. Trusts can be phenomenal tools. They can be so clear, so detailed as to who goes what, where, etc. But even the most detailed trusts, the most awesome on paper trusts are completely worthless if you didn't know how to put your assets into that trust. No funding. That's a very common thing that happens with people that go to attorneys that will create a trust for them, but don't teach them anything about funding. One of the worst mistakes that I saw recently in a trust was that the brother made this trust for mom, or like downloaded the form for mom. They, had it, like, were administrating it during mom's lifetime. Mom passes away, and guess what? That trust didn't have the requirements under Florida law to be something that survives the death of the person. So it just disappeared upon their death. And Florida law is really strict about those requirements. There's no fixing that. Okay. So if we don't know what we're supposed to do with trusts, we can also end up in similar messes as people with wills or people that have no plan at all. Traditional estate planning, and by that I mean like, you go to LegalZoom, it's becoming kind of a tradition, right? Download the form. Or you go to a law firm that will have a very quick conversation with you, and they'll like, yeah, next week we'll have the documents ready for you, just come in, okay? They fail you because of the following reasons. Number one, if it's a law firm that requires a lot of volume to make ends meet, they're going to have a low focus on your documents. I've reviewed many of those. They are riddled with mistakes. One of the worst ones I've seen was they thought that they were creating like a joint trust, husband and wife, and that, things were going to pass along to the wife first and then to the kids. Guess what? It didn't have any provision for passing anything to the wife. So upon the death of the first spouse, everything went to the kids. Yeah. Big law firms, on the other hand, right? They charge expensive hourly rates, but you're not going to get like the primo senior partner working on your plan unless you have, $100 million plus estate. They're not going to work on it. They're going to assign an exhausted associate that is required to bill well over 2,000 hours a year just to please their bosses. They're working 70 to 80 hours a week. They're exhausted. An exhausted person doesn't do the best work for you. Okay. But more importantly, short meetings, whether they're short because you don't want to pay the hourly rate, so you don't really talk a lot to your attorney, or short meetings because it's high volume based. And so it's like, yeah, that's $1,500 and we do this real quick, right? Those don't allow you to have the necessary conversations to understand how tax issues, family dynamics, your health conditions, how to hold assets, they don't discuss any of that. And when you don't have a discussion on any of that, you can't build a real strategy as to what to do when something happens to you. Okay. DIY kits sell forms with 0 consequences. Okay. You can't sue a form for failing your family. And that's why they don't care. They'll charge, $199, whatever it might be, to get it done. Quotas is not the best incentive to work with an attorney, right? You don't want somebody that's just going to do it because the boss tells them to do it because it's another billable requirement. It's not great for you. It's not great for your family. And it's not wise to just do it the same way that like your hairdresser did it or your pastor did it, because that's just the way that it's always been done by everyone. No, I reject that. Okay. I think that we as counselors at law have much more responsibility to our clients to actually do something effective for them. Just like in litigation, we are there through the proceedings. We know the strategy, we know the rules of procedure, we know what to present, we know when to even cancel hearings strategically for our clients. Like that level of strategy, you're not getting in traditional planning. And I don't understand why. You deserve more than that. Okay. Oh, and yes, it's one of my favorite sayings. Okay. Lo barato sale caro. Don't go with cheap. It's very expensive. As I mentioned, right? The bond, $150,000, just the bond. Legacy planning, like I mentioned, this is taking the time, not just with your counsel, okay, but also with your loved ones. If you're married, maybe with your children, if you rely on your adult children, taking the time to discuss your needs, taking the time to discuss what you have and why you have it, what you're planning to do with it, how you rely on it right now, taking the time to foresee tax issues that might arise if you do A over B, right? You don't want to rush through these things. This is your life, okay? Incapacitation can last years. Your death can result in years of issues for your family, so take the time to do it right. We have a system, it's called the Use AAA system. I came up with that in part because AAA saved me from several little mishaps when I was young and in college. So it's my little homage, but it's more about what should your counsel be doing. Updates, okay? You need an attorney that's going to update you about changes in the law. And yes, there are changes in the law that happen relating to estate planning. Strategy, again, right? Actually putting all the pieces together and making sure that they function in the way that you want them to function, so you don't end up being that lady who got nothing from the marital trust or the surviving trust thing because it was written the wrong way. Education, because you shouldn't be making decisions without understanding the consequences of those decisions. Advice from professionals, okay? Professionals. You shouldn't be asking, again, the hairdresser, the person who bags your groceries, etc., about what you should do if, like your son has a baby with so-and-so who you're not very fond of, and all those things, okay? That the advice, seek it from a professional. Advice regarding taxes, seek it from a professional who understands taxes. Advice regarding businesses, seek it from a professional who understands businesses, and so forth, okay? We have all that here. We're experts in real estate, business, and tax, because I'm a nerd, and I make my team a nerd. Accountability, you got to do things to make the plan actually work, okay? You cannot sit on a drawer. I know so many people that are like, oh yeah, mom has a will, and then she put it in this like thing and never looked at it again. It's from 2003 and many things have changed. And then just awareness, understanding things that you didn't know before. Just like in this meeting, in this webinar, you are learning what questions to ask between family members so that things get done the right way. Okay, so I'm going to tell you a little bit about what a legacy planning session is like with me, okay, and with our team. It's 90 minutes with me. It's all tailored to you and what you have, okay? It's based on that critical risk factors worksheet. I am analyzing all sorts of things about you at that moment in time and seeing many, many risks that you didn't know existed and seeing many opportunities that you probably didn't know existed. But we talk about assets, we talk about risk factors, we talk about your family and the dynamics there. We talk about things that you're missing. We talk about taxes. Yeah, tax secrets that generally estate planning lawyers don't know, because only 0.02% of lawyers in the state of Florida have advanced tax training. So we'll talk about those things too, and ways to avoid the tax traps of planning, okay? And it's confidential, because at that point you are having an actual closed door meeting with an attorney. If you don't have counsel in estate planning that understands taxes, that can have real consequences. Here's something that a lot of people didn't know. Estates have income taxes. If there was like, I don't know, an investment account left over and an IRA account left over, and they still were producing income that year that the person died, you're going to have an income tax return for the person that died and an income tax return for the estate. So I know so many people focus on estate taxes, but income taxes are the ones that are inescapable. So you should probably have somebody that your loved ones can come back to and say, what do we do here? What are we missing? Okay. It's very, very key. Our legacy planning system. Why do I keep saying the word system? Because remember, documents, they're just documents by themselves. It's going to fail you. Okay. You need to understand how to track your assets, how to account for them, how to fund things properly, how to tweak a plan if something substantially changes in your life. It could be that you had a surprise late baby, like my Aunt Sandra was 15 years younger than my mom. But a lot of things, right? Um, how to address your children and not just relying on putting it in a will about guardians, because your children might need a guardian when you're alive. Okay. Having a trained team that supports you, that understands what to do next, understands how do you fill out the form here? How do you fill out the form there? I have conversations with CPAs, with financial advisors, with the bankers of my clients, all to help assist them in getting things done right. Okay, so we have a system for that reason. At the legacy planning session, the most important thing that you're going to understand is here's what you can do next, because here's what you specifically are putting at risk by not doing anything at all. Okay. You don't get a do-over once you're incapacitated or dead. Remember those words from the probate judge, right? What would you pay? How much would you pay a lawyer to fix this so you don't put your family through this? But really, the legacy planning session is made to understand why your life should be approached in X ways strategically to help protect your loved ones. Okay, again, the golden ticket. I'm going to, as I put it with my clients, lovingly nag you to do something. I don't care if you have that call and it ends up that we're not a great fit for you. That's fine, but you at least reached out and asked some important questions to see if you should be working with us. You should then go and ask those questions of another attorney if we're not the right fit for you, right? I want you to do something, take the step, because I don't want you to end up being the people that I litigate for. Litigation is infinitely more expensive for loved ones than planning, okay? Litigation, I can give you an idea, okay? One person that came to me thought that mom had a trust. Ends up that mom totally didn't make a right trust. Brother that was the trustee or thought he was a trustee had transferred like $400,000 worth of assets for a trust that didn't exist. So now we have to undo some things. And that case, if everybody cooperates, if everybody is in agreement with what needs to be done, will cost around $50,000. Okay. That's with everybody agreeing. And they thought they had a trust in place for mom. So reach out to counsel. Let's talk about these myths because they exist, they're out there. So number one, people think estate planning, it's only for the wealthy. Okay. No. If you don't want to have your business be subject to complaints and claims, lose value, your family lose their only source of income if you own a business, you are going to want to do some estate planning. If you own real property, you are most definitely going to want to do estate planning because real property will be forced through the court system in more cases than not. If you have children, right? I don't want you to put your loved ones through the, hey, they turned 18, they get all of it at once and it's gone. There was a friend of mine who told me about their cousin, and this girl's father passed away, and at 18 she was to get, I think it was like 30 some odd $1,000, maybe 32. And when she turned 18, 2 weeks later, knocks on the door. my friend's house and it's like, it's gone. I've run through it in 2 weeks. In 2 weeks. That's how dangerous it is for immature minds to receive things outright. But that's what happens with no planning. So estate planning is not just for the wealthy, it's for people that want to prevent those kinds of mistakes. The second assumption is that your spouse automatically gets everything. If you're married, it just goes to them. That's not really the case. First of all, the majority of American families nowadays are blended families. Um, Blended families are those that have like a prior marriage, children from a prior relationship, and so forth. So that's actually the standard of day to day here. That spouse, because of being a blended family, will definitely not automatically get everything. Um, and one of the saddest cases that I had was at the end of last year. No, at the end of 2024. So this wonderfully sweet man in his 50s was suffering from cancer. He had opened up probate proceedings with a different lawyer about a year earlier because his wife died. He'd been married to his wife 35 years. This is a long-term marriage, right? But she had a daughter from a prior relationship. And as a result, really the only asset that was there was the house. But because of him not being her dad, he only had a life estate in it, which means he couldn't do anything, couldn't force a sale, nothing. And he desperately needed those funds to receive additional cancer treatment. He hired me. We were retained to do an emergency motion to see if we could get like a forced sale conveyance. And 2 weeks later, he passed away. I don't want that to be what happens to you. I don't like getting phone calls that my clients have passed away in the middle of litigation because of poor planning. I don't like that. And then, of course, I can't afford it right now. Your family can't afford the $50,000 expenses, or at least very few families can afford to do that. It's really like estate planning mistakes are something the wealthy can afford, but not the vast majority of Americans, okay? Majority of Americans can't afford not to have an estate plan because paying a $150,000 bond, which again, it's not like my client had any bad record. She was the daughter, nothing to indicate a reason for it. But a judge has complete discretion in requiring a bond, right? So that already drives you out of things. Paying 50 grand to do probate administration, thinking that you've got a simple one. Well, now it's turned into 4 because of who died and then who died afterwards, because we had to wait a little bit to gather funds. That can't afford ends up being, I'm going to lose easily 30 to 40% of the assets so that my family can get a contingent lawyer, or just the assets as a whole. And then they're going to go to the Department of Unclaimed Funds in Florida and eventually go to the state. That's the problem. Okay. Most of our clients pay way less than having to rely on the legal system here of probate. All right. The cost of doing nothing. Almost had my Long Island come out. Yeah, I was born in Jersey, and it's just close enough. So the lost time, okay? It's not just the cost of opening up the case. It's the time that it takes for people to get things done through the court system. I've had cases where like an emergency injunction, we couldn't get a hearing until 2 months later. 2 months, okay, for an emergency issue. And you're just sitting there suffering the consequences of this while going, what do I do? What do I do? I don't have access to this asset, or somebody's stealing it, or I don't think that you find that pleasant to go through. Your kids can be left in legal limbo. And so many parents forget to do any sort of guardianship planning for their children. Florida is a place where you can actually decide in advance, separately, who can take care of your children if something happens to you. Do it. A lot of family fights take place as a result of somebody passing away, because many people put a beautiful like face for mom or for dad, or whoever else is the elder they want to please, and they make it think like everything's hunky-dory. But as soon as a person passes away, their true feelings about their siblings and so forth come out. And if you don't have a plan, that gets exacerbated, just amplified, the chaos, the anger, the disappointment, all of it. And then, of course, if a business is left out, if it's not tied to whatever was created as a plan, that asset, which could have been worth hundreds of thousands of dollars to your family, is just gone. Okay, so don't do nothing. All right, thank you for spending time with me. I hope that you've learned a lot from this webinar, and go have those really serious conversations, and get over the ick feeling of discussing death and incapacitation. It's okay to feel vulnerable. We all are, right? Like I said, death, taxes, and change. That's guaranteed. But you're here because you care, you want to learn, you probably want to protect your family. You understand that we have no guarantee about what's available tomorrow. And so, again, my team's kind of left it there in the chat. If you want to schedule an appointment, schedule a 15-minute free call to see if we're a good fit for you in helping you with your estate planning needs, or if we can guide you to somebody that might be able to assist you in estate planning needs. Something else that we don't do that, make you aware, we don't do guardianships. So, but we can connect you with somebody that does. That's the important part. Go to the resources.